Court of Appeals is now in session.
Good morning and welcome to the virtual session of the Utah Court of Appeals. I don't know if all of you have had the opportunity to argue with us in the virtual setting. I just wanted to go over a couple of things either way for as much benefit of the judges as anyone else. I will remind you that we'd like you to be muted anytime that you are not actually engaged in questioning or answering, so we don't get any unwarranted feedback. Also, when you're not at the podium, so to speak, when you're not presenting your oral argument, we'd like you to mute your video as well, so that we can concentrate on the attorney making the argument. I see that there are 10 minutes on our clock. I assume, Mr. Christensen, that means that you have reserved 5 minutes. Is that correct?
Yes, Your Honor.
Perfect. Now, on the other side, we have two advocates with us today, and I'm curious whether you intend to split some time.
Yes, we've agreed to split it in half.
All right, and who's going first?
I am, Your Honor.
Very good. I think I now understand the lay of the land. With that, we're going to formally call the case. This is the matter of In Re A.B. And unless there are any questions, does anybody have any questions? Very good. Then we will ask the appellees to mute their video and their sound. And Mr. Christensen, you have the floor.
Thank you, Your Honors. Steve Christensen on behalf of the appellant, who is Krista Thompson, the mother of Aliana. The issue before the court, I think, poses an important issue for society, which is, can a mother take advantage of an offer of a great aunt and a great uncle to care for a child for the summer without the risk of having the relatives harbor the child and refuse to return the child to the mother? In this case, Krista Thompson always provided personal care for the child, or she made arrangements for her family to care for the child either while she was working or during a summer vacation at the invitation and request of her family members. Ms. Thompson had such an invitation 2 years ago when the Thompsons offered to care for the child during the summer. Ms. Thompson, a great aunt of the child, had been a trusted advisor, someone that Krista Thompson had relied upon, had consulted with, and had become close to. Had her invite Krista Thompson to send the child back to Utah for the summer, which she accepted. This came at a time when Krista Thompson was preparing to make a move to North Carolina, and this gave her an opportunity to take care of that move, as well as gave Aliana a chance to be with her family members. As the court has seen, this family had a culture of raising this child as a village. Heretofore, that has been seen as a virtue in our society. In fact, this family in Delta, Utah, had been very close-knit for the 5 years of Aliana. Before she started school, Ms. Thompson would go to work, and aunts and uncles would care for the child in her absence, spend a lot of time with this child. They were endeared to the child. And when Ms. Krista Thompson moved to Farmington, New Mexico, she saw a benefit in keeping a close family tie with, yes, Judge Mortensen.
Yeah, I wanted to ask you a question about the standard of review that you're asking us to apply in this case. You point us to KY versus Division of Child and Family Services, a 2010 case, saying that we should review the determination of whether the child was deemed neglected or abused, you say, but I think we should focus on neglect because that's the term that the juvenile court used. For correctness, recently, and this isn't really a change in the law, but I thought it was notable that the Supreme Court in the last month or so referred to this case and said it's has to be viewed through the correct prism, that it's a layered determination. The KY case had to do with a substantiated finding of abuse under DCFS regulations, as well as some statutory applications. And I compared that case with a number of cases from our court, both before and after 2010, some of them specifically referring to emotional mistreatment. And they seem to say that the determination should be reviewed with deference, and that we should only overturn it if we come to the conclusion that a mistake has been made. And in fact, there's a kind of a litany of per curiam decisions stating this standard and referring to in re BR, which the Guardian referred to in their brief, and you took umbrage at in your reply. So I guess that's a long way of asking, do you stand by your assertion that we are actually reviewing the determination, the finding of neglect for correction or deference?
Yes, I still say that this is a de novo review because the issue is a matter of law. The In re BR case dealt with a termination proceeding, and it certainly did deal with a mixed question of law and fact. But the question we're arguing to the court is that emotional maltreatment is not neglect. And that is the line that we pick out of KY, which is this court did not find emotional abuse, but rather chose to use the words emotional maltreatment. Yes, Charis.
And on that point, it seems like at least the appellee's brief filed by Ms. Harding engaged with that a little bit and seemed to indicate that, seemed to sort of acknowledge that there'd been something of a mistake made on the part of the juvenile court with regard to using the term emotional maltreatment and conflating it with neglect. But there's still three other reasons given by the juvenile court for the determination of neglect. And I think going to Judge Mortenson's question, how are we to review those? For instance, the one where there was a statement made or a determination made that mother's physical and emotional problems prevent her from being able to parent the child properly, that really isn't having anything to do with the finding of emotional maltreatment. That's a completely separate ground. And so I think Judge Mortenson's question is a good one. How do we review those other findings that are still sort of at issue here, leaving emotional maltreatment aside?
Well, on that issue specifically, Your Honor, first of all, the mother's physical and emotional deficits are not very well laid out in the court's findings. There's only a touch in terms of emotional problem. And in terms of the physical problems, this is something that was diagnosed and came up after the child was sent to Utah for the summer with the Thompsons. There's no nexus between the mother's condition and any potential neglect of the child because the child has not been in her care during that time. But even so, the mother testified, and there was no doctor there to rebut that she was able to function, she was able to care for the child, and she's still in a position to provide for the child. I understand from a standard of review perspective, how does the court look at that? But there is insufficient findings of fact at the very least that such a condition could result in neglect just because of the lack of connection between the disease and the presence of the child.
If-
Yes.
Can- Oh, can I
Says-
ask you
Yes.
this question, Mr. Christensen? In, along those lines, what is the proper perspective for the juvenile court in determining neglect? Do they look at present neglect? Do they look at the past neglect? I mean, the statute, you point out that the statutes are there's two, basically. I mean, both perspectives are incorporated into the statute. Here, it looked as if the juvenile court made both findings, right? In terms of placing AB with relatives without support, that sort of looked to the past, and then mother's physical and mental problems not allowing her to be a proper parent. That's sort of a present look at neglect. What is the proper perspective for this court in reviewing the juvenile court's determination?
Well, it's a good question. I think the court really should look at the past because the present is an artificial situation where the child is being harbored away from the mother, and there's no connection for the court to show that there is an ongoing problem. Mother has not had the opportunity to demonstrate her ability to parent because of the situation. In terms of the past situation, however, I mean, one of the factors of neglect the court considered was the lack of support, but I think it's important in this case to keep in mind that this is not your traditional case of support. There's no support order, there's no support agreement. In fact, the whole premise for the child coming to be with the relatives was this invitation of the Thompsons: we will take care of the child. We don't want you to do anything. We want to do this for you. This is a family member trying to help. And so to then bring that child forward and not consider that offer is sort of to change the rules of the game midstream. Yes, Judge Mortensen.
Would you agree that we're looking at the in the determination of whether the juvenile court correctly determined neglect, at least a starting point is the definition of neglect under the Juvenile Court Act? Do you agree with that proposition?
Yes, I do agree with that.
All right. Well, looking at that plain language, it talks about a failure or refusal of a parent to provide proper and necessary subsistence. Do we? I don't see anything there about there having to be an in-place order. Do you have any case that says there has to be an in-place order of support, or is it more broad than that?
Well, I don't have a case for the court on that specific issue, but I'm arguing that this situation was not the one contemplated by the statute. I mean, the statute's contemplating a situation where children are in need of support of a parent, but I mean, it's a common situation where grandparents and uncles and aunts step in and help a child, and their offer to do so doesn't negate the ability of the other parent to provide. In fact, the evidence before the court in this case is that mother did provide for the child. She always had a roof over the child's head. The child thrived in school. The child had counseling. The child always had what she needed when she was in the mother's care. The question here is, if the relatives want to come and take the child and so-called, and it's to the child's benefit, is there an expectation in the law that prevents families from making this kind of accommodation for each other?
Let me ask you a related question. First, the case KY was not construing the definition of neglect under the Juvenile Court Act. Do you think that's true?
Yes, I think that's true.
All right. Under one of the subsections of the definition of neglect includes lack of proper parental care of a child by reason of the fault or habits of a parent. Could emotional maltreatment be considered under that prong?
Well, I think the case stands for, even though the case is not interpreting the statutory definition, I think the case stands for that question being answered as a no. Emotional maltreatment, I think by definition in this case, is not neglect. And I mean, keep in mind, essentially, the underlying fact in this case is the court found that mother was gruff and she used somewhat harsh words to describe the child. But I don't think the court reached the determination that this was neglect under the statute. It basically said this was maltreatment, and thus, by the court's definition, it was neglect, and we're arguing that it should not be. Yes, Judge Christiansforster.
At its very core, Mr. Christensen, are you arguing, or are you pointing out, if you will, maybe that's a better way to put it, that there might be a legislative gap here, that a situation like this where there is emotional maltreatment that might not necessarily rise to the level of abuse, that this is a gap in our law that should be addressed legislatively?
Yes, I think so. I mean, and I think it's especially set up in this situation because we're dealing with, parents have difficulty with children, and that's part of the job. And in this case, Krista Thompson did what she could. She went to the counselor. She talked about what had happened. She went to her family. She talked about what had happened. How can I do this better? And granted, she did not respond well in every situation, and every comment about the child was not positive, but she was trying as a parent. And so I think the gap starts with just the family relationship, and it's magnified here because we have the inner workings of an extended family relationship. I don't think the legislature was expecting these statutes to be applied in such a harsh manner between family relationships where the natural ongoing development of parent and child relationships is something that they're working on. The state doesn't need to step in. This is a private petition where I don't think the statute's really contemplated this situation.
Thank you, Mr. Christensen. Unless either of the other judges have a question, looks like a no. We will turn the time over to Ms. Pierce.
May it please the court. Can you hear me? Martha Pierce, attorney guardian ad litem. You can't look at abuse, neglect, or dependency without looking at parental duty. Abuse, neglect, and dependency describe the inverse of parental duty, and I think it's not a helpful argument to say whether emotional abuse is abuse or neglect. Actually, it's abuse, because they both get you to the same place. Either one rebuts the parental presumption, and the emotional abuse can result from the inactions of a parent, which would be neglect, or emotional abuse can result from actions of a parent, which would be abuse. And I think one good case to describe what happened here is the In Re AFK case, and that's 2009 Utah Act 198. And there's a footnote 18, and that's another case where one couple was struggling with a pre-adoptive child. They gave the child to another couple, and they had arranged to do this. This was all, but Judge Orm observed that after a while, the child starts looking to another set of parents as the parents. And in footnote 18, it said it would be not in the child's best interest for the other couple to swoop in and remove the child from what she knows is her home. And that was the junction in this case where the aunt and uncle decided to take action, was when mother came before the school year was over and removed the child from school and treated her as a piece of property and says, she's mine, I'm taking off with her. And that is not the this is a mother who is all about the ownership aspect of parenthood, but not at all about the duties of parenthood. And I think counsel's argument has to do with trying to present the facts to you in a light most favorable to his position, and that slant is never successful on appeal because of Rule 54 requires this court to give some amount of deference to the findings of fact as found by the trial court. Are there questions? And in terms of the standard of review, I would refer this court to In Re ZD.
I do have a question, because it does appear that our case law, and you follow this pattern, and I don't fault you at all for this, because our long litany of especially procuring decisions seem to do the same thing. They seem to transverse rather readily between the Termination of Parental Rights Act and the Juvenile Court Act, picking and borrowing. For example, on abandonment, it seems like neglect findings of abandonment are cross-pollinated by the abandonment standard as outlined in the termination statute. And I'm curious if you have any case that you would actually hold up as say that's okay to do. I understand the court's done it, so on the one hand you can say precedent-wise we're off to the races, but I don't know that I find that to be compelling much.
Well, okay, do, because for instance, one ground for termination is neglect, but the definition of neglect is not in Title 5, it's in Title 300. And there are several definitions that, and for example, this court held that, the hearsay statute in 78A 6115, that applies to adjudications as well as terminations. So there's several places in the termination code that ask you to go back and look at the abuse, neglect, and dependency code, particularly in terms of the definitions of parents, the definitions of relatives, the definitions of neglect and abuse. So the statute kind of asks you to cross-reference between the two.
Well, the termination statute might do. Where going the other direction? Where in neglect determinations are we invited to go look at definitions in the Termination Act?
Well, one of the subsections of neglect is abandonment. And so you could look at abandonment, the definition in the Termination Act, but I suppose it could be a lesser form of abandonment if we're only looking at abuse, neglect, and dependency. But I agree, I can't think of a place in Title 300 that asks you to look at Title 500. Oh, as to the standard of review, I wanted to refer this court to In Re ZD, which is 2006 Utah 54. And that's actually the case that In Re BR primarily relied on. And in that case, that's a Supreme Court case, and they looked at the historical roots of Civil Rule 52. So, and I think that's probably the most helpful case for how you do a standard review for a bench trial, particularly in these cases where it's so fact intensive. And as opposed to a criminal trial where you're looking at one moment in time, abuse, neglect, dependency, as well as termination looks at a whole pattern of parenthood and looks at competency, and it has to look at it in terms of the child's needs, because how you treat a very healthy, robust 17-year-old is very different than the parenting skills needed to parent a medically fragile child. So it is so layered and so nuanced and so fact intensive and time intensive that there has to be some amount of deference given to the juvenile court. If there are no questions, I will turn it over to Ms. Hardy.
I don't see any questions, so thank you very much.
Shelley Harding, appearing for petitioners. I wanted to look first at how petitioners tee up this appeal. They say it's just a case of relatives caring for a child for a summer, and there's nothing wrong with that. And I just want to make sure the court is very clear that there is much more going on in this case than that. And first, it was not just a summer either. The most recent time was an entire year. But the history of this case is that the mother had relatives raising her child throughout the child's upbringing. There are lots of other facts, though, that really emphasize the neglect and abandonment that happened in this case, some that haven't been mentioned yet. The juvenile court found that the mother tried or explored selling her child on the black market when her child was younger. And the reason that I bring this up is I think it really highlights the lack of bonding. We had other relatives testify that there was no affection given between mother and child, that mother is pretty brusque and not emotionally supportive. We have mother cutting off people with close ties to the child because mother just didn't like them anymore. The mother's not financially stable and didn't contribute to the support of the child while she was with relatives despite requests for support.
Sorry, many of the things you're mentioning here were mentioned by the juvenile court in the written decision, but many of the things you're mentioning here don't seem to be tied to the 4 reasons the juvenile court gave for making a determination of neglect. So help me understand how some of the things you're talking about here, I'd like you to bring it back to the 4 reasons the juvenile court gave.
Sure. Well, neglect is the faults or habits of the parent that contribute to the lack of care of the child. So those faults and habits are continually foisting the child off on relatives, cutting people off who have emotional ties to the child. I mean, that's a fault that is creating emotional difficulty. But probably at this point, we should go straight to, I think, kind of the central issue, which is that the court found emotional neglect instead of emotional abuse. But again, in re KY, and this is just a rule of appellate review that you can uphold on any legal ground or theory apparent in the record. And if you look in the record, everyone referred to this behavior as emotional abuse. So the fact that the court said it was neglect can be corrected on appeal. It's actually emotional abuse. And this was a child who was oh, sorry, yes?
That's an interesting issue. I mean, so you specifically are asking us to affirm on this alternative basis. In order for us to do that, the alternative basis needs to be apparent from the record. And in order for a finding of emotional abuse to have been made, there needs to have been a finding of harm. And I don't have the statute in front of me right now, but there's a particularly specific finding that needs to be made in the context of abuse, that the child, has to be suffering some ongoing, I don't have the statute in front of me, I'm sorry, but I think you know what I'm talking about.
I do.
And here there was a specific finding that the child is thriving and doing well.
But she was suicidal when she came to her relatives. She was an absolute wreck. And that's why, if you look back through the record, that's why her mother brought her back to my clients, because they were both extremely depressed and this child was suicidal. And so that was just the culmination of the harsh treatment by her mother and this process of abandonment throughout the years and the lack of attachment.
But to find abuse, the emotional maltreatment to have risen to the level of abuse, you have to run it through a finding of harm. And that is, quote, serious impairment in the child's growth, development, or functioning. It has to, it has to be more than just sort of an incident that's a bump in the road and doesn't really affect the child long term. We have to have a finding that these issues have really serious impairment in the child's growth, development, or functioning. Do you think we can make that finding sort of obviously from the record?
Well, I think that the finding that the child was suicidal is a serious impairment to growth. I mean, this is a child who's been damaged for so long that she's reached the point of being suicidal. And it's something that she'll have to deal with for years to come. Her relationship with her mother and her sense of self and how that's been impacted by a mother who was not loving and supportive and who was actually very harsh and demeaning. So I think that the fact that she was suicidal demonstrates the harm. The other evidence of neglect is the domestic violence. Mom admitted to throwing a table in the presence of a child. Talked about the lack of support. I think it's also significant that the mother regularly turned down extra time with the child. So this is not an engaged mother who wants to parent. And I think it's also significant that the child doesn't want to return to her mother. So clearly this long pattern of parenting resulted in a child who doesn't want to return. And working in juvenile court, I can tell you how unusual that is. We have children who are very seriously abused physically, who still want to return to their parent. So I think that's another evidence of the harm. I think it's also significant that she threatened the harm, and there was more emotional abuse when the child was in the aunt and uncle's care, when she said, you better call your guardian ad litem and tell that person you want to come home right now. And it was another frightening experience for the child. I think the overall pattern that emerges is of a mother who was not engaged with her child for years and just had relatives raise the child until it got to the point that the child no longer wanted to be with her mother anymore. And that, combined with the actual emotional abuse, supports the neglect and abuse findings and the determination that permanent custody and guardianship should be granted to aunt and uncle. Are there any questions?
I don't see any.
Okay.
All right. Thank you for your presentation. We'll go back to Mr. Christensen.
Thank you. Thank you, Your Honors. Just a comment on Judge Harris's notation. I believe the record or the law does require the court, if there is an emotional abuse, to find that there is significant impairment or in growth, development, or psychological functioning, none of which the court addressed or made conclusions about in this case. On the issue of the standard of review, we're not claiming that this court should not afford deference in interpreting the facts to the lower court. Our argument is that the standard of review then requires this court to determine whether the court's findings create or justify a determination of neglect under the statutory definition. And that determination of whether neglect is present is a legal determination, which we believe the standard of review should be a de novo review for this court to determine whether that is present. Is there neglect? And on all 4 points that the court has found, yes, Judge Harris.
What you're describing is sort of our classic mixed question standard of review. We would defer to the lower court on findings of fact, and once those facts are found, then we apply those facts to a legal standard, and we give less deference on that step. Do you have a case that you can point me to that indicates that we treat this as a mixed question of fact and law?
Well, I mean, I think that there are, the only one that I think has been cited to the court is the question of the BR case, but that case is not exactly on point with this one because it dealt with a termination proceeding. But I do, without having them on the tip of my tongue, there are certainly cases that do what Your Honor has just described, which is give deference on the questions of fact, and then on the questions of law, this court determines whether the conclusion of the court below as a matter of law or if it's correct on a correctness standard, if the statutory definition of neglect has been established in this case. And we argue that in none of the 4 points that the court below found neglect is there a basis for neglect. There is not, the maltreatment is probably the most problematic. The other ones don't even come to get close to the definition. The Abandonment, we don't believe, is established. This was sending a child to a family member. There was always an expectation that the mother would be there. In fact, this whole case started when the mother picked up the child and a protective order was filed that was dismissed. So this was an attempt to keep the child from the mother rather than the mother not coming to claim the child. The mother kept in contact with the child. All of the arguments of counsel for the Thompsons really deal with facts that either were not found by the court or were facts developed through the case that were sort of the product of the case itself and not a product of the mother's parenting. We've already discussed that this is not your typical support situation. In fact, I mean, if the rules of the agreement were going to change, that support was going to start being required, then certainly the mother should have had the right to take the child back into her care rather than starting to require new support requirements. I think the only testimony about support requirements is sort of an allusion to copays and a request for reimbursement for some clothing expenses. But I mean, here we have a mother who has consistently provided support for the child and should have been able to have the care of the child and to be able to trust that the relatives were sincere in their offer. And then finally, the physical and emotional abuse, or the physical and emotional problems of the mother were not well established by the court. So we believe that mother is capable. That was her testimony. There was no medical expert to rebut that. And so based on that standard, we asked the court to determine that the statutory definition of neglect was inaccurately applied by the court below. Thank you.
All right, well, we'll ask Ms. Pierce, Ms. Harding to rejoin us. Thank you all for your presentation and your briefing today. We will take this matter under advisement and issue a written opinion in due course. We wish you the best and look forward to seeing you in person someday in the future. With that, we'll be adjourned.
This court is in recess until 10:30.
Thank you, Your Honors.